Imagine this. You build a company, raise thousands of crores from banks, and then your company's loan account is declared fraud. Now imagine something even bigger. You may never again become a director of another company. Not for 1 year, not for 5 years, possibly for life. Yes, the government is examining a proposal that could completely change the future of corporate governance in India. If this proposal becomes law, it could be one of the biggest amendments to the Companies Act 2013. But here's the real question. Can someone be permanently banned from becoming a director merely because their company's loan account was declared fraudulent? Let's understand why this news is important. This is not just another banking news story. This proposal affects company directors, promoters, independent directors, lenders, investors, company secretaries, chartered accountants, corporate lawyers, and every company that borrows from banks. If implemented, the proposal could significantly expand the grounds of director disqualification under Section 164 of the Companies Act 2013. That is why this development deserves everyone's attention. What is the government proposing? According to reports, the government is examining suggestions received from banks and financial institutions. The concern is simple. Some promoters whose companies have been declared as having fraud loan accounts continue to become directors in other companies. Banks believe this creates systemic risk. Therefore, they have suggested that such promoters should be permanently barred from serving on the boards of other companies. However, this is still only a proposal. No final decision has yet been taken. Why is this proposal being considered? Think about it. Suppose a company commits banking fraud involving hundreds or thousands of crores. Even after that, its promoter resigns, joins another company, becomes director, raises more loans, and repeats the cycle. Banks argue that this should not happen. They believe corporate governance must protect the financial system before another fraud occurs. Their objective is simple: prevent repeat offenders from entering boardrooms again. Current law, Section 164. But here's where things become legally interesting. Does the Companies Act already disqualify such promoters? The answer is not specifically. Section 164 currently contains several grounds of disqualification. For example, if a person is of unsound mind, if the person is an undischarged insolvent, if convicted for offenses involving moral turpitude or fraud, if the company fails to file financial statements or annual returns for 3 consecutive years, if deposits or debentures remain unpaid. But there is no direct provision saying promoter of a company whose loan account is declared fraudulent shall automatically become disqualified. That is exactly why an amendment may become necessary. What may change? If the proposal is accepted, Section 164 itself may require amendment. The government may introduce a completely new disqualification, meaning a promoter associated with a fraud loan account may become ineligible to act as director in any other company. Some reports even suggest the restriction may be permanent. However, important details are still under discussion. For example, will the rule apply only after a final fraud declaration? Will appeals be allowed? Will it apply to executive directors only or every promoter? These questions remain unanswered. RBI, banks, and fraud framework. This proposal also fits into the RBI's larger fraud risk framework. Banks are already required to identify suspicious transactions, issue show cause notices, conduct investigations, and classify frauds following prescribed procedures. The government now appears to be exploring whether corporate law should also impose additional consequences. Legal questions. But now comes the constitutional debate. Suppose a fraud declaration is later overturned. Should a promoter still face a lifetime ban? What happens if the promoter was not personally involved? What about independent directors? What if investigations are still pending? Will natural justice require a hearing before disqualification? These legal questions will become extremely important if this proposal moves forward. Practical impact. If enacted, this proposal could affect corporate governance, director appointments, bank lending, due diligence, board composition, investor confidence, credit approvals, and even IPO eligibility in some situations. Every listed company and every lender would need to revisit their governance framework. Conclusion. So remember, this is not yet law. It is a proposal under examination. Stakeholder consultations are still underway. Only after the government finalizes its decision and Parliament amends the Companies Act will such a provision become legally enforceable. Until then, the discussion itself marks one of the biggest proposed corporate governance reforms in recent years. Call to action. So, do you support this proposal? Should promoters linked to fraudulent loan accounts face a lifetime ban from becoming directors? Or should disqualification happen only after the court's final finding? Share your opinion in the comments. If you're preparing for CS Executive, CS Professional, CA, CMA, or want practical updates on the Companies Act, SEBI, IBC, FEMA, and corporate governance, subscribe to Corporate and Securities Law Compass and press the bell icon. Disclaimer. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. The content published on this channel, asterisk, does not represent the views, opinions, policies, or official position of my employer, any company with which I am associated, any client, or ICSI. All examples, case studies, and discussions are based on publicly available information, statutory provisions, judicial pronouncements, regulatory materials, or are purely hypothetical for educational purposes. I do not disclose or discuss any confidential, unpublished, or proprietary information obtained through my professional employment. I fully respect and comply with the SEBI Prohibition of Insider Trading Regulations 2015, applicable provisions of the Companies Act 2013, confidentiality obligations, and the internal policies of my employer. Nothing contained in this channel should be interpreted as the communication or use of unpublished price-sensitive information, UPSI, or any information that could violate insider trading laws. This channel does not provide legal, tax, investment, financial, accounting, or professional advice. Viewers should consult qualified professionals before making any business, legal, compliance, or investment decisions. While every effort is made to ensure the accuracy of the content, laws, rules, regulations, and judicial interpretations are subject to amendments and change. The presenter shall not be responsible for any loss, liability, or consequences arising from reliance on the information shared in these videos. By watching this channel, you acknowledge and agree to this disclaimer.